Hi, welcome back. I won't take too long because you've heard enough from the resident Article 2 labor rights experts. So we have our last panel now, which is entitled Article 2 Immigration and Frontier Workers. And we have three wonderful speakers, starting with Professor Colin Harvey from QB Law, John McGrath, who solicited Brian Feeney, co-solicitors, and then Professor Sylvia Demars from the University of Newcastle. That's it for me.
Okay, good afternoon, everyone. My name is, what is my name? Colin Harvey. My name is Colin Harvey. I work in the Law School of Queen's and very, very conscious that I missed this morning's discussion. So I'm sure that absolutely everything has already been resolved around Article 2 and spending a Friday afternoon going through all this. Well done, everyone. But the reason I wasn't here this morning might be relevant and interesting, that I'm a member of the Scientific Committee of the European Union Fundamental Rights Agency. So it was, and now we were having an online meeting this morning, so in Vienna, but online from Belfast, so EU and non-EU. So that's been an interesting experience, actually, of having a continuing involvement with the FRA and the charter and all of that in the circumstances of living and working here in Belfast and thinking about all that too. So I really apologize for not being here, and I'm conscious everything may have been sorted so already. Okay, what I'm going to do is think about some context, where we are now and what now. Really three themes: some context, where we are now, and what now in terms of what next. In terms of the title for today, Detaching Northern Ireland, I'm not going to really address all the areas mentioned here. I'm going to focus on refugee and asylum debates in particular. But just for background, for anybody who's just recently discovered me via social media, this is where I started my research career. In fact, my first book was published in a series edited by Professor McCrudden, Law and Context series, Seeking Asylum in the UK, Problems and Prospects from 2000. So this is really where I started off my academic career. In terms of context, immigration asylum law is vast. So there's going to be no comprehensive treatment of all of it here today. In terms of refugees and asylum seekers, I would say it's been, as we all know, a key human rights battleground over many, many years in public law, regional human rights law, international law, and that's likely to continue. So if you're looking for an area where diminution of rights is likely and possible, then the treatment of refugees and asylum seekers in the migration area is an area that we need to keep an eye on. We know that the Brexit project itself had a very strong migration-based theme, take back control and all of that. Migration was the target. In terms of anxieties, I think there's multiple anxieties that that this area will touch on. Obviously, for people affected by rights violations, take that as read. For Windsor Framework critics, and the title of my talk will touch on an anxiety about separation of Northern Ireland from the rest of the UK. But also anxieties around those who may be supportive of the Windsor Framework and are worried about what might happen on the island of Ireland in terms of the land border on the island of Ireland too. So in terms of context, there are a range of worries and anxieties about what might happen next. So we're thinking about Article 2 in a UK context then, and what might happen in the UK in relation to immigration and asylum issues going forward with the new government. But I think also with a changing landscape in the European Union, we're also thinking about what might happen on the island of Ireland in terms of divergence going forward as well, with the EU's new compact on immigration and asylum and Ireland deciding to opt in. And in some ways, the border becoming a sort of tension point for all of that. So we all know in terms of context, the UK and Ireland tracked each other very, very closely in this policy area while they were both in the EU, notionally in defence of the common travel area for British and Irish citizens, which I'm sure you've already heard about today. And what's important about that is that they didn't follow each other. They didn't follow the EU all the way down the road in terms of where the EU wanted to go, and very well known had opt-outs, opt-ins. And that becomes important in terms of this conversation today, in terms of what the UK actually opted into, in terms of, for example, the free movement of persons, not part of the protocol Windsor Framework, which had a strong focus on the EU single market and alignment of goods. And that highlights a story of the Windsor Framework that might take some people a bit aback, but there are still those of us who think that the Windsor Framework was a relatively modest mitigation measure in the context of what we're talking about today in Brexit. And in fact, one undertold story about that whole process is that people who would have argued that it should have gone further in some of these areas as well. We know in terms of context that a lot of the language around this can be very, very misleading and worryingly misleading at times, because we know for the many people on the island of Ireland, there isn't an invisible border. There is a hard immigration border on the island of Ireland, and there's a hard border on the island of Ireland. There are definitely two jurisdictions for people who are trying to work in different bits of the island where things are very, very different. So if free movement and all of that's not part of the Windsor Framework Protocol, why are we talking about the Windsor Framework and its implications for refugees and asylum seekers today? Well, a number of reasons for that we can highlight that you'll know. Obviously, human rights became part of the negotiations around this process. And Chris has written a piece in Irish Jurist recently published about the context for that. I was looking back at my own letter from 16th of November 2017 in Irish Times from Michael Farrell, Colin Harvey, and Liam Herrick, now Chief Commissioner of IREC. We are entering a critical phase in the Brexit process. At this juncture, it's essential that the Irish government stands steadfast in its commitment to the protection of human rights in Northern Ireland across the whole island. So the emergence of human rights into the language of the negotiations and into the Windsor Framework Protocol eventually. There's acceptance now, I think, albeit that there may be more to come, that this is covered by the relevant parts of the Good Friday Agreement in terms of the language of everyone in the community, both legally so far and governmentally in terms of recognition. Although on the governmental recognition, never quite sure whether previous governments and current governments are always on alignment on some of these things. Angstrom, for example, agreeing asylum seekers are not excluded. In terms of the issue of being underpinned by EU law on or before 31st December 2020, we know that the UK had opted in to immigration and asylum policy in an EU context, and we know that asylum, for example, was part of common European asylum system before then, albeit with the caveat that the UK had opted in on a selective basis to some of that. We also know for context that immigration and asylum are accepted matters within the UK constitutional system. For example, Schedule 2 Northern Ireland Act, nationality, immigration, including asylum and the status and capacity of persons in the UK who are not British citizens, free movement of persons within the European Economic Area, issue of travel documents, accepted matters. What does that context mean? Well, it means that Westminster and what happens to Article 2 at Westminster is going to play a big part in the conversation that we're going to have about immigration asylum. Where are we? We're in the Moot Courtroom in the School of Law, Queen's University, in the main side tower. Choose a name for that. So we know from the cases that have gone so far, Northern Ireland Human Rights Commission's case against the Legal Migration Act, Dillon case, Angstrom case, book case, research undertaken by the Human Rights Commission and the dedicated mechanisms about the implications for refugees and asylum seekers of Article 2 and its applicability. And the extent to which at this point it seems to be very, very widely accepted that we know what the status of Article 2 of the Windsor Framework is. We know that the civil rights of everyone must include asylum seekers. In the Human Rights Commission case, the argument advanced by the respondents that the RSE referenced in the agreement are limited to those which relate to the healing of sectarian division in Northern Ireland through reconciliation did not find favour with Colton J and either Angstrom or Dillon. While it is true to say that the agreement did not expressly reference immigration or asylum, there's no basis to exclude such individuals from the wide compass of everyone in the community. Everyone meaning everyone, right? In the human rights world, fairly straightforward. However, I'll just say something at the conclusion. One of the issues about immigration and asylum is you need to be very, very careful about your language, because words that are thrown around in Northern Ireland, like citizenship, who's present, residency, they all matter, right? And this is not an area for loose language. And if you look at parts of the Dillon judgment, the Court of Appeal here, paragraph 115 referencing citizens' rights, paragraph 65, a reference to residents. When I read that, I went, whoa, okay. Those words have meanings in the area that we're talking about that we need to think about. So we've seen the Northern Ireland Human Rights Commission case. We've seen just the extent of the gutting of the Illegal Migration Act, both in relation to the Windsor Framework and in relation to the convention. So maybe most helpful, I can say what now, because Billy showed me 5 minutes, and I'll think about some what now points. And I'm going to blend a number of generic points for discussion that may not make sense. So stick with me. One thing I want to say as director of the Human Rights Centre at Queen's is that university research centres are stakeholders in these conversations. So when there's work ongoing and the years about civic and community stakeholders being involved in the discussions, then don't forget that universities are part of those discussions. So, you would expect to see research centres at universities in the room if people are talking about stakeholder engagement. So this application in Northern Ireland of previous provisions of the previous government's immigration legislation has been clear. And that has confirmed an outcome of research supported by the Northern Ireland Human Rights Commission and in many ways vindicated that work. We know that Article 2 of the Windsor Framework will be examined by the UK Supreme Court. Seems to me, and obviously aspects of the fact that that's being appealed is disappointing to many people. And one reason stands out for me is that the meaning of Article 2, although after today might not agree, is tolerably clear, right? So I have a fair sense of what Article 2 actually requires. But there's a difference about the law not being clear and not liking what the law means. And I think that's a problem here. The law to me isn't unclear. It's just that people don't like what it means. And what happens in Northern Ireland historically then is there's the strategic use of tactical ambiguity. In other words, a theme since '98, a number of legal concepts that people don't like, they have a habit of saying they're ambiguous and they don't know what they mean. And I'm just worried about that. I'm very, very worried about what the Supreme Court in London might make of the framing of the Belfast Good Friday Agreement. Because we all know that human rights are a thread that runs through that document, but the agreement is often framed in very, very different ways, and that will really, really matter when it gets into the Supreme Court. Windsor Framework creates a complex system for Northern Ireland that is, in my view, not everybody will agree, consistent with the jurisdiction's already existing constitutional and legal distinctiveness. And nothing about the Windsor Framework surprises me. And the Windsor Framework is part of the nature of the UK in 2024. in constitutional legal terms, endorsed and approved by the Westminster Parliament, which remains, of course, sovereign and supreme. And that will have an impact on how we teach constitutional law, for example, to undergraduates, I hope, not just in Belfast, but in Edinburgh, Cardiff, and London and Birmingham as well. It's unsurprising, given the text and where EU had travelled before the UK left, that the rights of refugees and asylum seekers are included. That's not surprising. I think there's an argument for incentivising the UK to not dip below the standards that had already been reached in terms of where they had opted into before Brexit, and an approach that maps immigration and asylum that's consistent with EU law, policy and practice in a way that will assist with the functioning of a common travel area. And again, recalling what the UK had opted into before it left. The UK government and the Northern Ireland Executive need to review and act on the implications of Article 2 for immigration and asylum, and I note the recommendations that have already been made at that. You know, a major headline issue is that Article 2 desperately needs to be taken seriously at Westminster in an area like this that is an accepted area, and to use a phrase, needs to be mainstreamed within that system so that people realise that this is the way the UK, and essentially is now in 2024, as endorsed by the Westminster Parliament, and should be mainstreamed into all aspects of the legislative process, but that's going to be a challenge. I want to alert people to loose language, which you know, there are proper lawyers in the room. I'm an academic lawyer, right? But loose language in this area is problematic around jurisdiction, citizenship, nationality, and residence. These are words that need to be approached with caution because they have very precise meanings in immigration and asylum law. Even the use of the word present in refugee law has distinctiveness as to whether you're present, staying, lawfully staying. These are all particular words. Just going to end with a couple of generic comments and then I'll sit down about where we are. There's a major imperative at the moment at bedding in Article 2. And there's a sense in which people who don't pay a lot of attention to Northern Ireland will need to be walked gently through all of this around the fact that this is, you know, part of UK constitutional law now. That said, I think equality and rights landscape here is a mess. That is not unusual or uncommon, right? And that can simply reflect the complexities of particular national or regional contexts. But it's a mess that leads to unfairness to people that are intrinsic in that messy equality and rights landscape. So, for example, I feel sorry for anybody advising in this area at the moment, depending on where and which category they happen to fit in. I think we need to maximize the effectiveness of what is there, but we need to work out and we need to address in the longer term that human rights and equality landscape. And you won't be surprised to hear revisiting comprehensive protections, Bill of Rights, perhaps an incorporation agenda within the Northern Ireland Assembly, but also single equality legislation. Now, I realise at the moment the response to that maybe it's just not feasible politically. But I think in the longer term, we need to think about it because it's creating unfairness. I still think, maybe I shouldn't mention this, that an expert panel, as anticipated, new decade, new approach, and that never happened, would still be useful in mapping out ways forward in dialogue with the commissions and civil society. So just to conclude, immigration and asylum, these are broadly based reflections, is an area where there has been historically, you know, ripe for significant diminution, area where the courts, for example, have had to step in to prevent appalling disrespect for basic human dignity for individuals. There's a particular vulnerability here, and we're talking about not everyone, but a group of people that need human rights to really matter in this context. But I have to say, this is likely to be an area because of where the EU is going. Perhaps maybe the UK might not be going where it was going in the previous government, but still, I think this will be a major pressure point area. So I think, what do I think? I think there's a strong interest in dialogue and conversation that promotes alignment and convergence across these islands in relation to immigration and asylum. And the question in relation to the EU, however, is in what direction that alignment may be going in terms of those discussions as well. But just to end on the point, question mark, how likely is it that the EU will dip below the standards that were already set in the phase one common European asylum system that the UK had already signed up to? So those are some very, very broadly based reflections on immigration and asylum as an area where Article 2 is applicable, but is particularly needed as well. Look forward to discussion. Thank you.
All right, next up, we have John McGrath, whose paper presentation is entitled A House Divided Cannot Stand, Exploring Government Immigration Policy in a Post-Brexit Landscape. So if you're ready.
So my wife has asked for photos of me to assure that I'm not out gambling today. I'm not gambling. I've asked Lisa to kindly take a couple of photos to prove where I was. Thank you very much. It's lovely to be here today. In a room of distinguished people. I'm not a particularly distinguished man, so I feel slightly out of context. But it's a real pleasure to be here, and I hope what I have to say over the next few minutes may be of some use. Mr. Colin Hart very helpfully said we find ourselves in a tower, and the term ivory tower doesn't come to mind, but if it did, my talk would to transport us from the tower to the ground, and you would get an insight on the ground of how these things play out in the various worlds that I occupy. To give you some context, I began my legal training as a paralegal on Castle Street, in the office of the old office of John Finucane. I worked with a sole practitioner and paralegal principally in the area of asylum and immigration. I just come back from the Middle East, having lived in Lebanon and Palestine, and had some grasp of Arabic, which has increased and decreased over time, as those of us who speak multiple languages understand. If you don't use it, you really do lose it. I then embarked on a traineeship in a commercial law firm in Northern Ireland, and upon qualification, I practiced within the area of banking, corporate debt, bonds in an international law firm in Dublin. Eventually, after coming to my senses, I came back to Northern Ireland and found myself back doing some immigration, but mostly civil litigation. The title of my talk draws upon my, I'm a minister's son of a Church of Ireland minister, so of course a biblical reference had to come in somewhere. A house divided cannot stand. My experience of post-Brexit, the post-Brexit immigration landscape, and also labour landscape, because the two are twins in Northern Ireland. So in January 2021, we all know that the UK government launched a new Rolls-Royce immigration system that replaced the old Tier 2 skilled worker system. This was called the points-based system, and drawing upon the name, it dealt in points. And various points were given for a salary level for a prospective job you're hoping to take up in the UK. Points were added if you were, as many in this room, a PhD holder. If you're involved in STEM, various points could be offered. If you understood English, that being quite fundamental, I would think, to working in the UK, but not necessarily. You were offered points too. Upon the grant of 70 points, one was able to take up a visa in the UK, subject to having a sponsor. This obviously sat within the context of quite a racist Brexit campaign, and I think I can say that of all people, where much of the tenor of the debate came down to a numbers game. We want less of them, so there can be more of X. And unfortunately, this, in my experience, led to lots of very, very, very good people experiencing huge levels of anxiety about their position in the UK, particularly those EU citizens who, many of whom were born in the UK and knew nothing else but Northern Ireland. As we know, many EU citizens left the UK after Brexit, and this created real shortages in the labour pool. Now, I refer back to what I said about a skilled worker visa. Much of the skills that were required in the UK, hoping to be met by these visas, were unskilled. Frontline hospitality workers, those at the lower end of the health and social care spectrum, those jobs that many of us take for granted. And things like bus drivers, I know to this day there's a huge shortage for bus drivers in Northern Ireland. Many of these jobs, not exclusively, were done by people from the EU, but many were. And the government, in their wisdom, said, well, look, what we will do in our new points-based system, we will lower the salary threshold. Used to sit around £30,000. Now, some discounts were afforded if there were particular shortages in a particular labour pool. That salary is brought down to about 25,000, and even further discounts were offered to 20,000 level, particularly for those in the health and social care arena. Now, what this did is EU rights, and I don't need to rehearse this to anyone, although I didn't get a great score in my EU module in Queen's. You can shut your ears if you taught me. But EU citizens obviously enjoyed great rights in the UK, rights, freedom of movement, rights afforded to employment, and those family rights became particularly important after Brexit. Many of these rights are obviously diluted, and I think the government thought that, well, we will put non-EU people on the same pedestal as EU people. And in some cases, from what I've seen on the ground, you've had a huge influx of people from sub-Saharan Africa, from Asia, who have come to fill particularly health jobs in Northern Ireland. Now, in one way, being someone who was born in Kenya, I say, well, this is great. But I think there are issues too. First issue being it has facilitated an enormous brain drain from a lot of these other countries. And that is neither here nor there, and I'm not here to comment on that, but that is the reality. I know Kenya has basically banned a lot of healthcare workers from leaving their government healthcare jobs in Kenya to go straight to the UK. I think they put an embargo on that in a way that only a sub-Saharan government could do. I didn't say that, but so what we did see was a great exodus of skilled and bright people coming to the UK, which has benefited us. There's not many people in this room who have had interactions with the healthcare system that haven't been treated by someone who may not have been born in this country. And whilst that has been a great boost, there are consequences, I think, in some of these countries of origins, but I'm not here to comment on that. The other thing that we have seen is in countries like Australia, where you have a points-based system, the visa is given to the individual, whereas in the UK, the practice has been the visa is given to the individual through the employer. Now, what I have seen is that some employers, shall we say, are maybe more prudent in understanding their obligations as an employer than others. And what I've seen many times, and got many calls late at night of people who found themselves in the UK attached to a particular employer who sometimes isn't even paying them what they've been told to pay them. Sometimes the working conditions are horrendous. People experiencing huge levels of racism, discrimination. I know of one person who called me, and I think they were a healthcare worker and realised that they were being paid £5,000 less for the same job that their counterpart, who was from Northern Ireland, was being paid for the exact same job, exact same. So I think whilst in the government's wisdom, they felt they were doing a benefit for non-EU people by lowering the salary threshold to bring more people into the country. Unfortunately, the unintended consequence is that you have a system that disproportionately favours the employer, and the monitoring obligations, the imbalance of power means that a lot of people suck it up. I know many people that are in very difficult positions. And because they see a better life for their children here, endure. And they endure for the 5 years until they're able sometimes to make an application to be permanent, in which they can find employment that is not tied to a sponsor. The government, in their wisdom, I'm really on a roll here, in their wisdom to lower migration figures, they exited the Dublin Protocol by leaving the EU. Now, for a government that has such an aversion to asylum seekers and particularly failed asylum seekers, the one recourse that they did have when they were in the EU was by consent. And now, how this worked on the ground, because I never saw anyone get on the plane, but granted, I wasn't there very long. They could, if someone had a claim in another member state, they could, under that ledge, be transferred to that particular country. Obviously, that all ended. And what you saw at the start was a rush for the door for the government to make asylum decisions. And you saw a lot of quick decisions at that point. And then there was a drop off and nothing happened. A lot of immigration lawyers, they're very few. I mean, you could count nearly in two hands who does this in Northern Ireland now. So few. And many people discouraged by the fees or lack of fees. No one gets into this work to make money. You get into this work for other reasons, reasons of conscience for me. To be totally candid, it makes no business sense for me to do any of this, but I do it because my father was a minister and God probably is watching me. And I shouldn't have said that, but I was well, I'll have to say my prayers later. But yeah, there's the landscape for those who fall foul of the capriciousness of the UK, and I use that word, totally knowing it's on the capriciousness of the Home Office. If anyone is in doubt of that, go down and speak with Justice McAlinden, who does nearly all the JRs now, and he will tell you a simple thing that could be answered by a phone call to somebody. Phone call, they will not do it. It seems to be the unwritten policy to make life so difficult for everybody that your only recourse is judicial review. And I said to that gentleman at the back, if legal aid for judicial review is taken away in Northern Ireland in the way that it was done in England to a certain extent, I fear for many people living in Northern Ireland. I fear for them. I do fear for them. I mean, government policy shifted to, as we know, to a harder stance on immigration, with the bottom line to reduce net migration. Now, by lowering the salary threshold and by opening up many routes to non-EU people, net migration has gone up. Hence why a house divided may not be able to stand. The system, while seeking to promote skilled labour for those entering the UK to fill vacancies, has it's been part of a general increase to the migration trend. Now, part of my background, I said I worked particularly in corporate and commercial. For businesses hoping to gain workers, the route is very simple and very clear and very easy. One has to apply for a sponsorship license, enable you to bring sponsored workers. Now, whilst an asylum claim you might be waiting, I know someone who waited 7 years to have their asylum claim, living on £50 a week, 7 years. Child born in the UK, knew nothing of Northern Ireland, who waited. Anyway, if you are seeking to employ people through a government approved sponsor license, a decision can come in 3 weeks, and I've been through many of them myself, and the Home Office are very helpful. Unless you're maybe, I don't mean it's in a bad way, unless you're a Chinese restaurant somewhere, then they will make life very difficult for you. And it is quite as crude as that. Just to finish off, I know I'm under some time pressure. I want to finish off with giving you a couple of cases, obviously on a confidential basis with no names. One case, a gentleman who was born in the south of Ireland to Lithuanian parents, knew nothing about Ireland, a permanent resident down here, post-Brexit, finds love in Northern Ireland near the border, comes to Northern Ireland, tries to apply for a job, realizes can't get a job, realizes that he's going to actually have to be deported because he did not get pre-settled or settled status before this arbitrary cutoff point. This man's, when he said to the Home Office, well, during that time, I was in Lithuania doing mandatory military service that every young Lithuanian man must do. Home Office said no. So that's a JR that's ongoing. Second case, an Egyptian man, dual Greek and Egyptian national, gets settled, pre-settled status after Brexit, but the Home Office decide, no, we're not going to issue any more biometric cards. For those, these are ID cards that are very useful in your day-to-day operation in Northern Ireland. This man's schizophrenic, on disability allowance, recently lost his job due to a mental breakdown, goes to claim benefits, and because the Home Office have not given him a card, isn't able to get his benefits. The last case, and what is more worrying to me, and I know today's been about Article 2, but this is probably slightly different. A guy comes to the UK, claims asylum, doesn't work out, gets lifted by the police for something tenuous, is held on remand in Maghaberry pending the outcome of his criminal case, and the criminal case finishes, he doesn't get out. Next, I go to see him in Lauren House. When eventually he does get out, by that stage, his onward transportation to a detention holding centre in Gatwick is over. He's going there in a number of hours with a view to take him back to wherever he came from, which he left because he is gay and he's from sub-Saharan Africa, and if he goes back, he will be beheaded. That's the context in which many people are dealing with, and I don't want to come across as sensationalist or fatalistic, but as our previous speaker said, this is an eye where most decent people just don't know what's going on. They just don't know. And my fear is that if judicial review, recourse to legal aid, which is already under huge strain, continues to be eroded away, then the words Great in Britain cease to make much sense to me. Thank you very much.
That was a really great presentation. I was gripped, so gripped, I forgot to police the time. So next up, and this is our last speaker, we're going to go out with a bang. We've got, I hope you don't mind me saying this,
sure, that's great.
Brexit law superstar, Sylvia Damas,
Thank you.
who'll be presenting, I think this is maybe an amended or reworked version of the paper you wrote with Charlotte O'Brien. Yeah?
More thoughts since, yeah.
Yes. So I'll let you.
Hey, thanks again for having me. For those of you who don't know me, I'm Sylvia Demars. I am a this gets weirder to explain every time I do it, but I am a Dutch national with zero ties to the island of Ireland in any capacity, who has now been doing work on the island of Ireland for the better part of a decade, because I've got some bad friends sitting over there, basically. They needed an EU lawyer because in 2014 they had the question, this Brexit thing, if this goes ahead, I think that's going to be bad for Northern Ireland. And back then, my sweet innocent self went, oh, really? Why? Oh, man. Okay. Well, 10 years later, here we are. One of the most fun things I've done recently, and I'm not entirely sure if that was sarcasm or not, I'm sort of on the middle on this, was that with colleague Professor Charlotte O'Brien at the University of York, we wrote a report for the Northern Ireland Human Rights Commission on frontier workers, which we looked at and we thought, yeah, okay, we do EU law, we can do this, it's grand. Easy. I mean, I've learned nothing in 10 years, I think is what we're coming to here, in that it was not easy. None of it made sense. It was not straightforward. And we have more questions now than we did before we started looking at this, which I think is a common experience for people who deal with Brexit in any capacity, right? So I will quickly go through what the point of the report was and then take you through on a whirlwind tour of frontier workers as a thing. I took for granted that I knew what a frontier worker was. Like, I'm from Holland, right? So we're surrounded by other countries, and lots of people hop over borders and do work in all the other countries, and so stuff people do makes sense. It's covered by EU law. Sort of. Right. So I'll take you through, and I will focus in on slide number 5, which deals with Article 2. In what ways can we possibly deal with Article 2 to try to undo some of the harm that Brexit has caused here? All right, I'm really glad that our previous speakers already raised ignorance as being a really, really big problem, because that, I think, is the thing that's going to bite the hardest when it comes to frontier workers and the effects that Brexit has had on them. All right, and I'll explain why. So the report, back in the day, Eilish and Company put out a tender for this and said, just answer some questions about frontier workers, right? We know Brexit's happening in the island of Ireland. People work across the border all the time. You got folks living in the Republic who come and do work in Northern Ireland. You got folks living in Northern Ireland who go work in the Republic. So what's that gonna do? We know that the common travel area is still there, so that's gonna cover some of this, right? And then also frontier workers are going to be in the withdrawal agreement. They're getting some rights from that. And then we have implemented the withdrawal agreement. So is this all okay? And Charlotte and I were like, sure. And then we looked at it and went, oh no, oh, really not okay. So what are the coverage gaps was basically our task. What has gone wrong here? What have people effectively lost in this transition? Now, our starting point for this was the rather stupid question of defining what a frontier worker is. And we came to the hilarious finding that actually the EU has never really specifically defined what a frontier worker is in any of its primary law or its leading secondary legislation. You just sort of know what it is because the Court of Justice has, occasionally said, yeah, sure, it's people who live in one member state and work in another. That's a frontier worker. Right? It doesn't matter if those nations are not actually connected to each other. You can technically be a frontier worker if you, work in Germany and live in Spain. Technically, as long as you move back and forth regularly, that's frontier work. But it's very nebulous, right? There isn't a clear definition of this in statute, which was a surprise to us because the EU loves itself some statute, right? They really love printing out reams of legislation every single year. Nothing to clarify this. And I think on reflection, I know why. It's because for everyone in the EU who doesn't leave the EU, it doesn't really matter that much. It doesn't need a clear definition because you can live in all those member states and you can work in most of them and you'll just treat it like a worker and it doesn't really affect you. That's where you get the problems. So where are they covered? I mean, they're covered by the treaties. The Court of Justice has long said frontier workers are workers. Good news, right? They're covered a bit by the Citizenship Directive, which in one place only mentions that if you're a frontier worker, you might be able to apply for permanent residency more quickly than other kinds of workers, just because you're doing that hopping back and forth between member states. You might be able to qualify on that basis. The workers regulation says, yeah, frontier workers exist and they can get medical treatment in the state in which they work. Great, so that we have 3 random rights that are set out in detail with everything else is sort of being implied. And then there's the Social Security Coordination Regulation, which is the only one that actually defines what a frontier worker is. And it says, the person pursuing an activity, so far so good, as an employed or self-employed person, okay, in a member state and who resides in another member state, fine, to which he or she returns as a rule daily or at least once a week. Uh-oh, that's where the alarm bells started ringing. Right? And that is the only statutory definition of a frontier worker that the EU has or has ever worked with. Now, that implies a very, very specific type of work. What if you're doing something else? What if you're a seasonal worker who spends months on the farm over in country 1 and then goes back home to live in the country of residence, but there's not that regular travel? The EU basically doesn't care because this is not something that has to be enforced between EU nationals or amongst EU nationals. We cared because that's an issue now. The other thing that EU law really doesn't deal with is the fact that you can have what we call reverse frontier work, right? Normal frontier worker is someone who has one EU nationality. They live in their state of nationality. So let's say you're a German, you live in Germany, and then you work in another member state. So say the Netherlands. But you could also be a reverse frontier worker. You could be a German national who lives in the Netherlands but works in Germany. EU law doesn't account for that at all. And the problem with that is that those people then have to basically apply for their EU rights as if they are self-sufficient. You have to say, I am self-sufficient in this country that I live in because of my employment in the other country. Again, all of this is technical and not necessarily a problem, but it becomes a problem when you start stripping away the underpinning EU movement ability. All right, so we had some really big questions. There seems to be a general understanding that the frontier worker is just your man or your woman who lives in one country and hops on a train across the border and does the job there and then comes back home every evening. That's not the reality. So what happens to all those other people? The withdrawal agreement, I mean, it was an opportunity for people to wake up to this potentially being an issue, and they sort of did. To give credit where due, the people who drafted the withdrawal agreement did say, maybe we need to define what a frontier worker is. Maybe we need to mention them specifically. And they did. They are, in the withdrawal agreement, UK or EU nationals who pursue work or self-employment in line with the treaties in one or more states in which they do not reside. Cool. But what about work and self-employment? Do those have the standard EU definitions? And if so, are we then back to that limited understanding of what you need to be doing and how often you need to be doing it? Does this set aside that idea of returning home daily or at least once a week? Or does it imply it because it references as in line with the treaties and the Social Security regulations are in line with treaty law and so on? So we don't really know. Now, here's where it gets really messed up and you realize these people had no idea what they were doing, right? There's then a great line in there that also says that family members of frontier workers are also covered by the withdrawal agreement. Okay, cool. But it specifies that they have to reside in the host state in line with EU law prior to Brexit. All right, let me paint this picture to you again. If you're a frontier worker, you live in your country of residence and you work, aka host state, in another country. Your family members, therefore, will not live in the host state. Your family members will live with you in your country of nationality outside of the general realm of EU law. So why do they need to be covered by the withdrawal agreement? Nothing's really happening to them. So this is where we started going, uh-oh, maybe the people writing this up did not really understand the situation they were dealing with. This is a bit of an issue, right? So we have this weird situation where reverse frontier workers, the people who went to live in another member state and work in their state of nationality, they're completely covered even for residency rights, and their family members are as well. They just have to say they're self-sufficient. But the people who are doing the bog standard, I live here and then I go and commute to my job, weirdly, their family members are sort of covered in a way that they never could use, right? Big issues. So to make matters worse, you can continue residing and working in your host member state. However, the UK has taken, well, negotiated hard for this, really, gotten the right to deport people on the basis of UK domestic law post-Brexit rather than on the basis of EU law. That's my first flag for real diminution. Basically, I think our Home Secretary can just decide she doesn't really much like the look of you and you're a threat to something and off you go. Whereas under EU law, obviously, there's a much more intense process for actually deporting people who are otherwise living in line with EU law. So really big problem, especially if we're dealing with family members who may or may not be of EU origin, right? That is where I'm starting to get concerned. So beyond that, what rights do they have? Well, I mean, again, the people drafting this seem to have just done a real hash job of this. They recognize that frontier workers need a right to enter and to work. That's correct. That's what they're doing, right? They live in their home state. They just go to this job. Great. And then it goes on to say, you can get a document saying that you are a frontier worker. It's declaratory. I'll come back to that, all right? But I don't know what you're supposed to do with this. I think it's printed, but I'm not 100% sure. It just says frontier worker with a date on it. Okay, great. Now, there's non-discrimination rights, same way there are for all EU national workers in the EU and all other people covered by Part 2 of the withdrawal agreement. And they did that thing where there used to be a protocol to the treaties that said UK and Northern Ireland can be more generous to each other because of the common travel area. They copied that over very explicitly in Part 2, so that also applies here. The rights are for a lifetime unless you stop being a frontier worker. I'll come back to that. And beyond that, all your Social Security rights are maintained. And so this is all fairly bog standard stuff in line with everything else. All right. Enforcement, here we run into the general part 2 problem. Enforcement is different. We now have the Immigration Monitoring Authority, obviously, and after 8 years, there's no more preliminary references. Is that a diminution? I would think so personally, but you know, hard to say. So what has the UK government done with this? Oh, they've made a nightmare of things, all right? I'll try to go through this relatively quickly, but the first thing that the British government did was basically just tell everyone Irish that they didn't need to worry about any of this. Great stuff. Don't bother applying for a frontier worker permit. Don't bother applying for the EU settlement scheme. Just you're Irish, it's fine. And then they enacted something that gave the Irish a special status where it's like you do not need leave to enter or whatever. All other EU nationals did. So they either, if living in the UK, applied for the EUSS, or if they were a frontier worker, so not living in the UK, but working in the UK, they could apply for a permit. Okay, so far so good. The frontier worker regulations make it clear that the only people who should be applying for those are EEA nationals who are not also British nationals and don't primarily live in the UK. All right, so we're getting more of a restriction on who they can fit in this scheme. Then that's primary residence, okay, really unhelpful. They stress in the frontier worker regulations, again, that their family members can apply for the EUSS. But if your EU national family member needs a frontier worker permit, your family's not going to be living in the UK. So why would they, you know, again, I just look at this and I think, did they understand what a frontier worker was? Now, they do here recognize that frontier work can take many shapes. All right, they say self-employment counts, workers count, you can be a retained frontier worker. The UK translation of the EU law is actually quite generous, right? You can now be a frontier worker in the UK if you return to your country of residence at least twice in 12 months. That seems to work better for agricultural workers and people like that who do seasonal types of jobs, all right? So that seems relatively nice. However, then there's still the problem that you might have a bigger gap than that in your work. And if you lose your frontier worker status, you can never get it back now, all right? That's forever gone. And beyond that, if you were to stay frontier worker, you have to have compelling evidence, whatever the hell that means, that you are still seeking work as a frontier worker, which, I mean, most of the time, it's not really that you're seeking work, it's that you're doing something that happens one time a year. Or maybe you're a builder and you do most of your building on one side of the border, and every now and again, someone contracts you to do some building close on the other side of the border. That would normally be frontier work in EU law, really briefly, but who knows at this point, right? You have to have compelling evidence that you're still doing the frontier work. The idea of compelling evidence was once upon a time overruled by the Court of Justice. It's actually going beyond the EU law in terms of the requirements for proving that you had worker status or could retain it. And the UK government just sneakily brought it back in, right? So real issues there. In terms of the guidance the UK government gives, absolute rubbish. We're on the 25th iteration of the EUSS guidance right now. When I wrote the report, we were on 21. When I first presented the report, we were on 23. It's been an ongoing love story. It's really not clear who gets what out of it, and the government keeps changing its mind, which is really, really unhelpful. Now, frontier worker permit guidance. Irish citizens do not need to apply. So my guess is most did not. And just thought, common travel area, man. Just go, just hop over, do our jobs. Okay. Once again, we have that weird thing where they keep saying your family members can't get a frontier worker permit, but they could apply for residency rights in a state they don't live. Okay, congratulations, that's great. No mention of reverse frontier work at all. You just have to hope that there's some social security coordination that's not covered by the withdrawal agreement. And then the real pinch point, where I think the Commission might want me to have some more thoughts about this. You have to show that you are doing genuine and effective work. That's the EU law term for proving that you're a worker very generally. But obviously, the dimensions of frontier work are very different. So that concept logically should have a different meaning. And it's not at all made clear what that would be. They are very explicit, though. If you are doing work that is, in their eyes, short-term, temporary, irregular, and unstable, you're not a worker. You're providing services. And services are not covered by the withdrawal agreement. So you're then not covered by the withdrawal agreement at all. All right, so there's some really nasty stuff here at the end. Again, you can deport people based on UK law and so on and so forth. Mostly a faithful adaptation of the withdrawal agreement itself. So the problems go up higher, right? We don't have the UK here having done something demonic with a great EU law. We have a really big problem that no one really seems to understand how to protect these people. So where do I sit with this on Article 2? Charlotte and I looked at a lot of ways in which these rights might be mitigated and ended up figuring that most of them are covered by one or two general rights identified in the Belfast Good Friday Agreement. So it's either a right to freely choose one's place of residence, which is restricted in some ways by the fact that you might need this permit, you might lose the right to work or live somewhere else, or it's equal opportunity in social and economic activity. You could link a lot of these issues to either of those. Things that might go wrong. You could only get the status up to Brexit. If you didn't get it then, you're not going to get it now. You can be deported under domestic law. Your family reunification claims, really important for people with non-UK families who they want to join them. Impossible now. A lot of these are similar as they are to workers. My real thing that I want to highlight here is that a lot of people are going to be doing frontier work without knowing it. You know when you are an EU national and you are working or living in another member state, right? If you're just literally exercising free movement. And you can't do that anymore after Brexit. You can't pick up now and say, I'm going to go live in Germany. That's not that you would know, you would encounter immigration. It would be clear to you something was happening. If you are a plumber on one side of the border and you just go fix a leak on the other side of the border, no one is going to tell you what you are or are not doing and what rights you may or may not need to ensure you protect. So my number one concern with this, and I think I've stressed this point before, is not that this is going to be a problem right now. It's going to be a problem if ever the UK changes anything about its social security regulation, and then these people will discover that they are, in fact, not covered by the EU protective scheme in the way they thought they were, or they should have been, or they might have been. So I don't see this as immediate litigation, the way that refugee asylum claims would be. I see this as a slowly boiling kettle, because obviously we have the CTA, and the CTA has a social security memorandum, but it's not enforceable. If the UK decides tomorrow that people from Ireland can no longer use the NHS in Northern Ireland, what you gonna do? Not call Ghostbusters. I know that's the normal answer to this, but I don't think it will help in this particular instance. So I see this as causing small problems as they keep tinkering with secondary legislation over in Westminster, perhaps having an ongoing impact within Northern Ireland as well. And these people just don't realize that they should have applied for a status, or they might lose it if they do X and Y. I think that those are the real issues where future claims are going to come from. All right, so what do we say? Please redefine frontier worker. Make it clearer that there's so many other ways in which people can do these jobs and that they might be covered by this. It's a tall order, but that is the thing that I think legislation, or Article 2 jurisprudence would have to go for. Just say, you've made us lose more than you realize. This cannot have been intended. It is a diminution of how we live our normal day-to-day lives. And I'm very glad I don't work in practice. So, good luck to the people who will have to do this at some point in time. All right, thanks very much.
I told you we'd go out with a bang. So we still have 20 minutes for Q&As, and Daniela has the microphones. Anyone have any questions?
Thank you. And thanks very much. I'm very biased, but it's been great to see this focus on immigration in terms of the impact of Brexit. And I have loads of questions, but if it's okay, can I ask two? The first was just regarding the impact of the Irish government and the changes that it might be making, particularly in immigration law and policy. And this has come up quite frequently. It came up in the Commission's, they call it the Divergence of Rights report, and it came up earlier today in terms of women and peace and security, that Ireland just isn't really considering Northern Ireland or the Windsor Framework as they're proceeding with their own plans. Excuse me. And I was just wondering, do you think that this is happening again, and particularly with the EU Asylum Pact? Just on an initial reading, it has mandatory border protocols that apply to any external EU border, and I'm not entirely sure whether the Irish government has considered, could that have impacts on the land border? And then, of course, we've seen some really worrying rhetoric around the land border and the common travel area and checks just this week. And I'm just really curious what you guys think about the impact of Ireland's policy in terms of the Windsor Framework, and whether they're actually thinking about it at all. And the second was, I was struck by the example John gave about the EU citizen and the digital status issue, and then the frontier workers' loss of rights. And we recently met with the Independent Monitoring Authority, and I think they're just sort of starting to realise the intersection between Article 2 of the Windsor Framework and the Withdrawal Agreement and citizens' rights protections. And I was just curious, in terms of someone taking a case in Northern Ireland, would you be looking to combine the citizens' rights protections of the Withdrawal Agreement with Article 2, or could someone just go for Article 2 if they were, is that stronger? I'm just curious how you'd see a case like that working. Thank you.
Barney?
Yeah, Roisin Mallon from the Equality Commission. It's really just sort of picking up on that theme of divergence of rights on the island of Ireland. I think Colin mentioned it there, and it's been raised there in the context of immigration. I just would welcome views, maybe particularly Colin, in terms of some of the other areas of divergence of rights, north-south rights, where he sees the sort of the key issues are, and in particular what might the implications of that be, particularly looking about north-south cooperation. So just welcome views on that. Thank you.
So could I ask two questions? I think it's probably to the panel in general. The first is that the provisions in the Good Friday Agreement, whether the general provision on civil rights or the specific provisions that you were mentioning, Sylvia, are applicable, and Colin mentioned this, to everyone in the community. And Colin said, the term everyone is easy to understand. I get that. But the issue, I think, arises more in terms of what the community is. And in that context, I think there is an interesting discussion to be had as to whether it means Northern Ireland residents, whether it means something less connected, whether it means the island of Ireland as a whole, whether it means the whole of the UK. What is the community here that's applicable? So that's the first question. Second question is, and I think this is particularly arising out of Colin's contribution, there's a potential dilemma here, isn't there, in terms of there being at least two different objectives in the protocol. And one of them is non-diminution, Article 2. The other is a more amorphous understanding, but it was clear at the time, which was to prevent a hard border on the island of Ireland. And Colin, you've said, of course, there is, to a degree, a hard border. The dilemma arises if there were to be a reduction in EU rights, and Ireland, of course, follows that diminution in EU rights. But that would lead, if Northern Ireland retained its extensive protections under old EU rights, that would lead to a strengthening of the hard border on the island of Ireland. So what's your priority here? Is it to reduce or minimize borders on the island of Ireland, or is it to retain a higher standard in Northern Ireland? Because I'm not sure, at least in the scenario that I've sketched out, you can have both.
Maybe John, do you want to start first with the question on citizens and Article 2? Or not? Yeah. Yeah, okay. Yeah. I'm looking at you, Colin. First, trying to remember your name. And then
Yeah, no, I'm called Colin, so I don't know. I don't know, no. Una, in terms of question, maybe preface the answer to all three questions by, maybe it's because I wrote my PhD on, when things were going badly wrong in the UK in the 90s, did a PhD at Nottingham on refugee and asylum law and looked at what was happening in Europe European context and in the UK, problematic elements there. I've never seen the European Union as the bastion of human rights promotion and protection. You know, from day one of the work that I've done, I've always approached the EU in a slightly with a critical human rights lens, that the EU, like any intergovernmental organization, when I thought about human rights, I thought about the Council of Europe. So as a human rights lawyer and the UN and all of that. So so I want to frame a response in that way, because when you approach it from an international human rights or a human rights informed perspective, you look in the EU in a different way, you know. So, and even during the Brexit discussions, having around the negotiations and others, that was the framework. And some of the glowing references to the EU had to be because the EU is doing and continues to do some really appalling things in the area of refugee and asylum law. You know, there are people dying in the sea trying to enter Europe. So like, I don't have a rose-tinted view of the European Union. I'm based critical of the EU as anyone. And so with that framing in mind, the direction of the travel, it's a great question, right? And so the direction of travel in the European Union, if you look at what's happened in terms of the Migration and Asylum Pact, I've said already whether that is going to dip below the phase one common European asylum, I would, but the direction of travel is clear. You know, the EU is becoming more restrictive. It's not becoming a human rights utopia for refugees and asylum seekers. And what's really interesting about the direction of travel in the EU is that it is taking and I know this with another hat on, it is taking a very, very intense interest in border management and what's happening in the external borders of the European Union, to the extent at which, you know, in the FRA hat, we've done a report on human rights at the borders and recommendations in terms of people who are managing external borders. If all these abbreviations, if I can remember what they mean, but the EES, right, which is the entry-exit system that the EU is introducing, also the ETIAS system as well, albeit there are all sorts of limitations and exceptions. The direction of travel there is very, very clear, you know, in terms of that. So there are implications for, you know, again, and I don't take a rosy view of Irish government either, historically. So that the Irish government state also needs to up its game to comply with the things that we're talking about today. So, you know, to personally, you know, I'm on the Irish Human Rights and Equality Commission. I'm conscious the Commission is very aware of this. Also involved with the FRA and mention Article 2 any opportunity I get to do that, and whether people have thought about that. But yeah, there's a major issue. You know, I also we're sharing with, you know, why Ireland did what it did on the protocol as well. Like, you know, obviously there's a very strong commitment to the Good Friday Agreement and North-South cooperation and no hard border on the island of Ireland and, you know, all of that. But Ireland's also very protective of its single market access and its strategic south of this island, you know, likes the state that it carved out. So, so all of that is something that we all need to think about when we're thinking about Article 2. And I would say, don't forget Dublin in that, you know, to what Dublin can do to feed into the conversation on the island around equivalence, divergence and convergence. And it's not just Westminster, as much as I love Westminster, obviously, but Roisin's question about, I can't really replicate, or the commissions have done brilliant work, including really, really significant research reports on a whole panoply of areas where there's a risk of divergence over the longer term before on the island of Ireland. I would say this area where you've got an EU direction of travel, you've got a UK direction of travel, and where you have a land border on the island of Ireland is probably one of the major pressure points, and where I think the commissions work together in two contexts: the Joint Committee, the Human Rights Commission, and Irish Human Rights, but also we need a name for that three commission body, you know, sort of, other than the three commission body or whatever working group it is. But so the commissions cooperate as well around Article 2. And I think I would bring the agreement back into that and say that the equivalence, a few things in the agreement have been forgotten about, not just the Bill of Rights, but the Charter of Rights for the Island of Ireland, the equivalence doctrine, and people don't just mention them because they like to mention it. I actually think the charter idea that was in the agreement now, for example, of getting people on the island talking to each other about rights protections and what's happened wouldn't do any harm to have that conversation around equivalence. But, I prefaced my talk by saying I think some of the governmental and political cliches around this are misleading, because for many people on the island, there's a hard border. And I don't just mean in terms of racial profiling and immigration, but I mean just practical day-to-day lives. Depending on where you live and where you move around, it's very, very difficult. So we need to mitigate against that as best we can. Chris's question now, yeah. Like, I think this is a great question. And this is what really worries me about the loose language thing, right? So obviously from a human rights perspective, everyone is the word we latch onto. But the next few words really, really worry me about what might happen to that, because in the community has potentially all sorts of, I don't, you're boss, you're a proper lawyer, Chris, and all this stuff, but in the community and immigration asylum context can mean all sorts of interesting things, as to who is, so that thing I mentioned about refugee law, international refugees is this phased thing about who's present, who's lawfully present at stages. And when I hear that phrase, you worry, and that's the issue about the Supreme Court. And if there's a generous and inclusive and propositive interpretation of that, then that needs to be followed through. But it seems to me that, and one of the reasons I didn't get into different areas of immigration asylum laws, the debate at the moment is still on the stage of copper fastening the scope of Article 2 successfully via the Court of Appeal here or the Supreme Court, so as then we can go on to advise people and apply it properly. But I think it's reasonably clear, but it's going to the Supreme Court. Who knows what, like the Belfast Good Friday Agreement thing would worry me as to what the Supreme Court might make of that chunk of text going in there and those things. So that'll need to be thought about. It's a good question about north-south and where it might go in terms of the island and what are prioritized. I've turned it back to the equivalence doctrine on the island of Ireland. I still think that's not taken sufficiently seriously in any institutional discussions. At a recent meeting of the commissions, talked about, are these ideas being talked about or presented to the North-South Ministerial Council, British Irish Intergovernmental Conference, all the forums where people meet? Are they being presented with the concepts and ideas that we're talking about today on a routine basis? So they're mainstreaming them into the way they think. To avoid that, because my focus at the end was on dialogue with the EU, it's in everybody's interests around these islands to try and stay broadly on the same page, in a good sense, right? To not go backwards. My view on Northern Ireland is really, really, really desperately trying to steer clear of anything constitutional today. But my sense would be that if Northern Ireland, it would be wonderful to think that we would plough ahead and there would be a more advanced position in Northern Ireland. But I suppose if we do get into discussion in the next 2 decades, which is where I think it's most likely those comprehensive conversations will happen in the longer term, then my sense that levers into that conversation discussions too. So I would say there's no harm in Northern Ireland being ahead of the discussions in terms of equality and rights or in particular areas, because if the direction of travel here in the next 2 decades is a bigger conversation where the more comprehensive things are now, I think, most likely to happen, then that levers into that conversation, those things as well. So that's probably sort of personal priorities and my delusional sense about where things might be going on the island of Ireland. But so if Northern Ireland enters that discussion with, a strong and inclusive Bill of Rights and a Single Equality Act, that would be great.
Sure, I'll tackle this with much less optimism. I, as a bystander to most of these discussions, I would guess that if the EU proceeds in a direction that will result in Ireland, say, reducing migration rights, the UK government will jump at an opportunity to do exactly the same over here. And I think that they will try to justify it by saying that the priority of the Northern Ireland Protocol or the Windsor Framework is to avoid that hard border. And we've worked so hard to make sure that hard border didn't come into existence. We finally have, the government back in play, the assembly is running again, and so on. So surely we wouldn't want to undo all of that. And also we hate foreigners. So boom, I think that would be my end assessment of where we are headed. That's not a sign of approval. It's just, I've lived here for 20 years now. So I think I've seen how quickly the government is happy to sacrifice migrants at the right of a quick publicity win, and they will take it. As far as the community goes, that becomes a more interesting question, I think, because coming at this as an EU lawyer, I think we would run into real problems if certain EU nationals were treated differently with respect to their engagement with the United Kingdom as others were, on account of them either living here or working here, if those two things were separated out as being part of distinct communities. So for the sake of that not becoming an issue, I would think that a semi-broad concept of it would be the only workable one for equal treatment purposes. So that might include the entirety of the island of Ireland, but I think you'd have to have a connection to Northern Ireland in some capacity to be part of that community. I feel like if they cut out people who weren't resident in Northern Ireland, you would raise really big questions about, well, what is the point of allowing frontier workers to have any retained rights in that case anyway? They're going to end up with different rights from other workers. Why is that okay? Right? Or why is it okay that a frontier worker who lives in the United Kingdom and works in Ireland somehow gets the full protections of this, but a frontier worker who lives in Ireland and works in Northern Ireland gets something different? That would fly anathema to me to both a reasonable interpretation of equivalence in the Belfast Good Friday Agreement and equal treatment in EU law. Sure.
So let's say somebody
Yeah.
and applying for entry into the
Yeah.
Are they within the community?
Interesting. That depends on when they applied. No, if they do it right now, well, that's interesting. I don't think that either the EU or the UK would want to get involved in that because they're now third country nationals, technically speaking. Or if they're Irish, oh gosh, okay. If they're Irish, they wouldn't need to apply, so they would be excluded from this, correct? So if they're not Irish and they would be applying, say they're another EU national, they would be treated as third country nationals now. And I feel like that is a hornet's nest no one will want to touch again. Yes, because they would have been prior to Brexit. I think would be my argument if I had to make that argument. All right. I might be completely wrong about that, but that would be my pitch.
I'll pick up very briefly on this point. I was involved in the case as a young paralegal, and the importance of which was lost at me at the time. I just remember various delegations of Syrian men talking about Irish passports coming into the office, and the case predicated on a child who was born in Northern Ireland to Syrian parents from Aleppo, if I remember. Child's parents apply the Irish law, as in a refugee born in the state of Ireland. Child is an Irish citizen. So this man applies for the child to have an Irish passport, like many other Syrians. Most go into the void. And this one gentleman's child is granted an Irish passport, an Irish citizen. Now, this creates furore. So the disgruntled other fathers take a case, a JR, Q Mercer, KC involved. Case runs, Irish government a notice party, UN a notice party, and the case settles. And I can't find the judgment to this day because the child was obviously anonymized, but I can't find it. But all I remember was there was a period, I think it was Justice McCluskey actually was sitting in the JR court in those days, and there were discussions that happened behind the scene between the Irish government and the British government about what the definition of in the state means. And this is the Irish government. My wife, white US national from Florida, permanent resident, if she applies for an Irish passport, like I have done for many US people, will be granted quite quickly. And the argument about the state will favour her particular application. Now, when I've done applications for people from Nigeria, from Egypt, they have been refused because immigration decisions down south are at the discretion of the minister. Now, in those days, it was Charlie Flanagan. I couldn't tell you who it is now. But the interpretation of when it suits people for Northern Ireland to be part of the state and when it doesn't is something I don't yet understand. And the culmination of that case was, I think the fathers lost the case without prejudice. And since then, I have not heard of any other child who wasn't permanent, who was born in Northern Ireland before they became permanent in the UK, or a British passport holder in the UK being granted an Irish passport in Northern Ireland. And this is when these sort of grey areas, the theme I get from today is grey area. Because I've been to various illustrious conferences that touched on the Windsor Framework, and I heard no detail coming from any politician. I've heard more detail today than I've heard in the last 5 years, so thank you all. Much of it is gone. But I think the Irish government have an opportunity to be a helpful force here. Because whilst the diminution of rights for asylum seekers, and particularly children, refugee children, may be, we say, maybe under threat. I mean, they hold recourse if they are born in the island of Ireland to a citizenship of the Republic of Ireland. But my fear is that there were discussions behind the scene of which I don't know what was said, but something changed. And I think I would be very keen to hear from Irish government when they choose to interpret the state to include Northern Ireland and when they don't, because it does have an impact on what happens up here, particularly because the rights that attach from being an Irish citizen, as we've talked about in North, not that a child's going to be working over the border on a site.
You never know. There are specific rules about when children are allowed to be frontier workers in the UK legislation.
Oh, really?
Yeah. They have to be 13 years old and I think qualify for Britain's Got Talent. I think are the conditions under the they're allowed to do it. Basically that kind of thing.
So I mean that's something that I can offer no more detail on that. But I do think it's interesting that it suits the Irish government when they're unhappy about what happened here and when they're not. And obviously these are political machinations. But let us not be under the illusion that there isn't discrimination down south, because it does happen there. And I said, on a ground level, the waiting times, if you're Australian, American, Dutch, if you're applying for an Irish passport, in my experience, it is quite quick. And if you're not, and you have the same route, the same rights, it is much less quick. But none of them are really quick, as Mr. McCrudden says.
I think we've run out of time. You want to?
No, it's just one of the things, and this may be, that it's an observation that's probably been addressed this morning, but given the scale of what's been discussed today, and Council wasn't here this morning, but in Article 2, is the resourcing and infrastructure in both states sufficient in order to do some of the things that are needed to be done in order to make sure that is a question, because talking about areas like this, where Westminster needs to be engaged, and thinking about what we talked about, Dublin, and and even thinking about the joint committee and the way that's worked over many, many years, often these structures aren't resourced in a way and hardwired and in a way that structurally that will make sure that can do the things that we're talking about this afternoon. Consciously, probably discussed that this morning. So, and I think that's as true of Dublin as it is of London. To make sure that happens. But maybe
We've run out of time. But if you want to continue the discussion, we can. And please feel free. If you have somewhere else to go, you can also leave. Go ahead.
Just respond. But One of the clear implications of litigation in the last couple of years is that there is an enormous amount of money being spent on defending community council. So there's one part, there's a question about overall resources. There's also a question of where those resources are spent.
Yes.
And at the moment, as an observer from outside, it looks like quite significant resources that should be spent on trying to comply are being spent on resisting entirely sensible arguments as to why they're not.
Could I ask a question? As someone who's not an academic, a lot, I'm in touch with quite a lot of members in sort of peace building groups in the loyalist community. And a lot of I mean, this may stray from what we've said, but a lot of loyalists who I've spoken to see the Windsor Framework, the direction of travel as, now they would put it as an economic United Ireland, quite maybe a crude understanding of what we've talked about, but they sense their feeling is, and it touches on immigration because of what happened in the summer, that in a sense, the ground is being prepared for a unity project, and the divergence from UK law that I think has been touched on, well, the potential for a divergence anyway, and the drift that may come in a sense, suits the direction. Now, I don't want to get into this because much above my pay grade, but what I want to know is things like the storm at break, when they were raised, window dressing, from what I saw, is there a democratic deficit in Northern Ireland? Because my fear as an immigration practitioner has been a lot of community tensions have come at the door of refugees, migrants that are nothing to do with them, but they have become essentially the avatar, the scapegoat of the fallout, the economic fallout, I would say, of Brexit, and before Brexit, austerity, and you just go back in time. But is there, and I appreciate maybe no one wants to say, is there a democratic deficit in Northern Ireland? Okay, yes. That's all I needed to know. Yes.
If by democracy you let's go to it, that the unionist and longest community is going to have a veto over those Brexit arrangements, the answer is they are not.
Yes.
And that's clear.
Yes.
And so if your definition is one that essentially wants to have cross-community support, and that's democracy, then there's a democratic deficit.
Yes.
But not if you define it in a different way. Where I think there is a democratic deficit is the ability of Northern Ireland to feed into the EU decision
Yes.
In a direct way. And the democratic deficit in terms of the ability of Whitehall to understand what the implications are of its decisions, often unintentional, for Northern Ireland. And so it comes back to Colin's point about resources. Clearly, Whitehall is not resourced for attracting the kinds of problematic issues that are being raised, which are immensely complicated.
Yes.
But also immensely important for the nations.
That's very helpful.
Yeah, to elaborate, I said yes very quickly because I'm reminded of a conversation that Aoife and I had with a member of the Labour Lords in part of Parliament, I think in 2017, where we pointed out that the whole way this was going demonstrated that the UK is profoundly undemocratic, and he called her Chairman Mao. So this was a life highlight, I think.
Never be able to look at this.
Okay.
She was Chairman Mao, I was just with her.
Well, but there's red bedecked everywhere, so we're sort of like, this is the we've got the color scheme right anyway for all of that. Just very briefly, I think there is an issue with, and this is a real challenge for educators everywhere. And I know many people in the room have spent their lives trying to do this, of misinformation and disinformation about, and I actually don't target that at particular communities. I think what I mean by that is that there are two distinctive legal jurisdictions on the island of Ireland, with their own divergent systems and complexities that are, and that's why I wanted to underline the point about the language around, you know, the invisibility of the border is only invisible in a very, there are very big differences between the two jurisdictions. And so misinformation, disinformation about what's actually going on. The second part of that is, like I mentioned the point about the nature of the UK Constitution and constitutional law. You know, Chris, you wrote something about, you know, we were teaching for years in Scotland and Wales and Northern Ireland here about the pluralist UK that had evolved in a post-1980. And Scottish public lawyers were all assuming, you know, we were all assuming this is a thing. And then Brexit came along and thought, oh, that was all. So there's a question for educators in UK constitutional law and what's getting taught in universities and elsewhere about that, because in some ways, from day one, what happened could be plausibly celebrated as an example of a pluralist and diverse UK that was recognised and accommodating its very distinctive composition as a strength. That argument may be lost entirely now, but that is a plausible argument that could have been made around all of that, all endorsed by the sovereign Supreme Westminster Parliament. That is all a plausible argument. Now, I have my own views about the future, which I'm definitely not going anywhere near today. But I think not properly communicating and articulating by both governments just the distinctiveness on the island now, the way in which UK constitutional law is, but also seeing sometimes diversity and pluralism and difference as a strength and not a weakness, of not trying to reinvent highly centralized models of UK constitutionalism, you know, because, you know, I would say there's an entirely plausible small U unionist and loyalist case for and as Chris has pointed out in another one of his recent multiple articles, the extent to which actually loyalism played a key part in drafting parts of the Good Friday Agreement that we're talking about today is really quite remarkable. So there's a job of work really for all of us to do in talking about some of that, I think.
Yeah, I'm putting my foot down because I have a meeting to go to. So please join me in thanking our wonderful panelists. Also thanking all our wonderful speakers throughout the day. Some of you may not know this. This wasn't about Article 2. It was about me. All along, I was brought into the post-Brexit governance NI project as a lawyer. They just forgot that I was just a trade lawyer. And then Article 2 blew up. And I was there left saying, sorry. So this was my big apology. And, you know, the quality of the presentations have been such that I think it's fine now. I can be forgiven. So thank you, the audience, also for turning up, for making it such a great event. So I'll let you go now. Thank you.